So mediation may not be the best approach for a high conflict divorce. Now, I want to be very careful when I say this because this is a red flag. This is something you're going to want to talk to your attorney about who knows more about your situation and your goals. This is generally a possible red flag. If you have a high conflict couple, it can be difficult for them to sit at a mediation table with one neutral mediator and keep the conversation productive. So if you're high conflict, if you think that there might be tendency to argue in a disrespectful way or with heightened emotions, or there's a chance that someone's going to walk out of the room, or we're not going to keep on task and we're going to talk about a side issue rather than the main things that we need to decide, mediation might not be the best approach. We might want to consider alternatives like collaborative divorce or litigation to sort of support your goals and make sure that we have a productive process in place. Another red flag that mediation might not be the right process. And again, it could be talk to an experienced attorney that knows you and your situation. But power imbalances can be a red flag for mediation because the power dynamic that happens outside of the room comes into the room. There are a lot of power imbalances that are possible. If there's past domestic violence or current domestic violence, that's the most extreme version of a power imbalance that can make it very hard for both people to fully participate in the mediation with confidence and with feeling a sense of safety. Now, remember, in a mediation, it tends to be, in Connecticut, the mediator and the two of you, no lawyers in the room. So that setup can be very difficult when there's a power imbalance. Sometimes there's a power imbalance on something less dire, like financials. One person knows all about the financials and the other person knows less about the financials. Well, that can create a situation in the mediation because the person that's less confident in the financials might not feel comfortable sharing what their perspective is. The reason that it's so important to have a lawyer, in the context of mediation, it's often called mediation review counsel. But the reason it's so important to have a lawyer is a lawyer can help you figure out how to support mediation if they think it might work. Let's take the example of a financial knowledge imbalance. One person knows everything about the finances, the other person really knows very little. Well, your review counsel might recommend that the less knowledgeable spouse meet with a financial planner, get more educated on the financials. They might suggest that you request a session with the mediator that has your review counsel in the room so that you feel supported during those discussions. So again, these red flags, the power imbalance red flag, sometimes it means you should pick a different process. At other times, it means that the mediation should be tailored a little bit more to make sure that these issues are addressed, and that can turn it into a much better process for you. So another red flag about mediation, why mediation might not be the right mousetrap for you, is when there are concerns about transparency. So mediation relies on the full and transparent exchange of information between the parties. It doesn't have the court there to make sure that we're following strict discovery guidelines. We're offering things, we're making representations. It's a less formal out-of-court process. And if you have concerns about transparency, it might not be the best process for you. So what I would do is make sure you raise that with your counsel and get advice about your concerns about transparency. Find out if there are any ways that you might be able to make sure that documents are accurately exchanged in the context of mediation, or if maybe mediation isn't the best way to go for you. Maybe collaborative divorce or maybe litigation is a better process for you given the concerns about transparency. So it's a red flag. Talk to your lawyer about it. figure out if that means that mediation should be tweaked a bit to address that concern, or whether a different approach might be better. Another potential red flag about when mediation might not be the best approach for your divorce is when one spouse is not really into it. Like maybe they're reluctant about mediation, maybe they're reluctant about the divorce itself. So mediation requires both spouses real earnest participation. And that shows up in a few ways. Shows up in making deadlines, agreeing to them, and living up to them so that the process moves forward. It means exchanging information transparently and on time. So this issue of when one spouse isn't really interested in the divorce or the mediation process, that can make it very difficult to have a successful mediation if they won't get on board. Mediation is a client-driven process. And so one client can't drive it by themselves. It takes both of them, outside the room and inside the room, living up to their commitment, making commitments, living up to them outside the room, and then in the room, really engaging in the negotiation process and being open and communicative and listening in the room. So those are things that you're going to want to address with your counsel. If that's a factor, if you think your spouse might be someone who's going to not participate or really want to drag their feet, mediation might not be the best approach for your divorce. And the last thing that we want is for you to have a mediation and then have to start over in another process. Let's try and figure out the most likely successful process that lines up with your goals before you start it. The other thing I want you to share with your counsel before you pick your process or before you hire a mediator or start your mediation is how complex the financials are. So if you have really complex financials, in a divorce litigation, you might see things like business valuations or discovery that explains how a compensation structure works. You can dive deep into all of those things. But in a mediation, you don't have those traditional tools. So just because you have complex financials doesn't necessarily mean that mediation isn't the right process. But before you start a mediation, when there are complex financials, you want to have a discussion to make sure that, one, that mediation is the best way to proceed, but also that if you do mediate, how you can make sure that those complex financials are being handled. Are you bringing in a financial expert into the mediation to help make sure that you understand how these things work? Are you agreeing to do a business valuation, one business valuation from a neutral on the side, so that you make sure that there is a full understanding about the financials by everyone in the room? It's not, again, necessarily that mediation isn't the right approach if there are complex financials, but you do want to be mindful that complex financials can require some additional thought and structure in the mediation itself, or maybe a litigation or collaborative divorce makes more sense for you. It all depends. The key is bring it to your lawyer, talk about it, think about it, and make sure you set yourself up for the best chance of having a great, smooth process. If you have any questions about the mediation process, whether you're a great candidate, whether you're an okay candidate, what we can do to make a mediation successful, or whether there's a better process entirely, please reach out. We'd be happy to talk about it.